Okay, we'll jump into chapter 21. Share the screen. So I'm just going to record class here in Newnan and post that link to course info. But you're welcome to stay clued in with us right now on the Zoom call. You can ask questions if you want. I just don't know what happened in Carrollton, like technology wise, if Hamadreza has just not been able to get logged in. That computer room in our Carrollton classroom has been having some issues. Like the whole computer is not communicating at all with the camera on the wall. And I've put in like 2 weeks worth of requests. The service desk hasn't gotten fixed yet. And now I'm wondering if like the whole setup of the computer is just not working right. And that's why Carrollton can't log in. I don't know, because I'm not in Carrollton right now, but for today, I will just record class right here and post it on Coursden, since it's our last class of the semester. Before we jump all the way into chapter 21, I have a couple of announcements. I've decided to extend your final exam since this is the last week of classes and you guys are like swamped and busy. I'm going to extend the final exam clear into the 30th, which is Tuesday before like the official final week starts. I think that's like marked as like a reading day or something. What do they call it? Yeah, reading day. So I think it's like a day off where everybody has like no classes, but you can prepare for finals, whatever. I'll give you through that to take your final exam on the 30th. So it pushes past the weekend. Your mind tap deadline is still Sunday. So if you're going to skip the final exam, just make sure you don't skip that last week of mind tap homework because you don't want to get a 0 and lower your homework average, especially if you were like borderline between grades and you were satisfied with where you were. Borderline, you don't want to like drop a point or something. But I'll extend your final exam to the 30th and I'll extend this last extra credit that's open right now, the court observations, through May 5th. So instead of having it due this weekend like it originally was, because again, there's a lot going on this week with like finishing up this chapter and doing your final exam, I'm going to extend this extra credit court observation through May 5th. So I'll post all that on Coursden and update on the calendar. I just wanted to give you guys a heads up that I was granting some extensions because I care about you. I've enjoyed having you in my class. I want to see you successful. And if giving you just a little extra time to kind of, you know, you can get it done and over with. Like it'll still all start at the same time it was planned to start. It's just giving you a little more cushion and getting things wrapped up. If that can make a difference in you scoring better on your final or getting an opportunity to do extra credit that you may not have had time to do this week. Next week starts final exam, so you may have a little more flexibility in your schedule since you don't have your same schedule of face-to-face classes, or maybe you're headed home already at the end of the semester and you can go do a court observation in your hometown if you want to. It can be any courtroom. Just go to your county website, like search for your county, you know, superior court clerk, and you can see a schedule of what time they start. You know, in my experience, it's usually been around 9 a.m. It's usually when the courts start, but you can look and see what they have on the calendar. If there's something that's interesting to you, the courts will post, you know, there's civil cases, criminal cases. And if you read through the directions for the extra credit activity, it's pretty flexible with what kind of cases you could observe and write about. The one thing I just don't want to see you writing about is something that is like extremely sensitive personal information. So anything like, you know, like child abuse or, you know, like a sexual assault or something like that, that's just way too many personal details. You might have observed that in court as, you know, part of all of the different things you observed, but there should be multiple cases that you observe, you know, interaction with the judge and calendar call or something like that. So there ought to be something else. But otherwise, we studied criminal law in this class. So there's, you know, plenty of, you can talk about crimes, misdemeanors, felonies, whatever people are charged with, civil cases, contract disputes, business cases, anything like that. Even the procedural stuff. So maybe the crime or the thing someone's being sued about is not something that you feel like you were familiar with based on what you learned, but you still learned about the procedure and how that works and, you know, the roles that people play in the courtroom when they are the plaintiff or the defendant or the prosecutor, judge, bailiff, all that kind of stuff. So there should be plenty of material to write about if you go and attend some kind of court hearing of some sort. And there's daytime, evening, anything like that. If you have any questions, you can send me an email. But I've got in the instructions for this extra credit, it's like I've got several pages of like tips and ideas, and I even have a link to the local, Carroll County and Coweta County circuit calendars. So for the local courtrooms, if you want to go hear any of that. And then another announcement that I was asked to make in class is on Monday, on the 29th, here on the Newnan campus. And those of you in Carrollton are invited to come down too. If you don't want to drive, there's a shuttle that goes back and forth too between the campuses. And starting at noon here on the Newnan campus, the financial aid office is going to be hosting a workshop for completing your FAFSAs for next year, because the Department of Education has made some changes and there's been some glitches and some different complications that have come up. So they're hosting, like a workshop that is useful to anybody that's in school that has to complete the FAFSA on how those changes might affect you, and maybe answer any questions you may have.
Do you happen to know when the scholarship forms are due?
I don't. But I know that the only thing I know about that stuff is that the scholarship portal is very cumbersome. Like, jumping into chapter 21. So we wrapped up our first half of the employment law unit talking about just basic employment laws, and things that affect employer and employee relationships. We talked about, at will employment, how it's not just for the boss to be able to fire somebody that's not working out for them. It's also for the employee, the worker, to be able to not feel trapped in a job, that they have the right to leave a job for no reason whatsoever, and as long as it's not in violation of their contract, if their contract requires a certain amount of notice or certain stipulations about who they can go work for next, nobody can hold you hostage. I had a few students that were surprised to learn that, the law doesn't what requires 2 weeks notice. That's sort of a cultural norm that people put in notice before they leave a job. But at the same time, don't be surprised if you put in 2 weeks notice and somebody says, thanks, see you later, and sends you home that day. Because again, at will employment, they're not under obligation to keep you there, just like you're not under any obligation to necessarily give 2 weeks notice. So you want to keep that in mind. For this chapter, going into chapter 1, it's still employment law issues. We're going to talk more specifically about employment discrimination and the laws that affect, that realm, that protect against people being discriminated at work. And a lot of this is, when we look at the law, and some of the laws we've talked about that came from before our country was a country, some of our common law that we inherited from England and made it our own over the last couple hundred years. When it comes to discrimination laws, employment discrimination, a lot of this is a lot younger. It's been more the recent decades. In fact, the largest statute covering multiple areas of discrimination is what we commonly refer to as Title VII. Title VII has more than just employment law in it, but for our purposes, we're talking about the employment law section of Title VII. And Title VII is actually celebrating its 60th birthday this year, because it was passed in 1964. So it's the 60th birthday of Title VII. And the protections it provides against discrimination in the areas of what we refer to as like protected classes of people. It protects people from being discriminated against on, these categories that represent immutable characteristics, so things that are who you are and you can't change, and it's unfair for someone to use those things against you, to discriminate against you, to treat you differently or unfairly in an employment context based on these particular characteristics. And so when it comes to Title VII, we'll talk about, the foundation before Title VII. We also had discrimination law that came through in the post-Civil War era. But it took a long time to get from those, which we refer to those as Section 1981 claims. And we'll talk about that a little more as we go through this chapter, through Title VII. And then since Title VII, we've had a couple of amendments that have kind of broadened who it applies to. We've had some Supreme Court cases in the last few years that have also broadened how we apply it, who it applies to, those, further defining those kind of protections. And who knows if we'll see another civil rights amendment in the future. I was part of a research team this past year proposing employment legislation. So this is an area that I've done a lot of research and writing on, that it's kind of been too long since we've had an amendment in this arena. So we'll talk about what the law is now and where it stands. But President Bush in 1991 was the last time we had an amendment on this kind of employment law area, like there was a statutory amendment to the law. We've had Supreme Court cases and decisions, but we're sort of not really quite in harmony yet with some of those decisions, the way they apply to other discrimination. So, okay, so jumping into discrimination. So again, out of the civil rights movement, you guys kind of familiar with the 1960s civil rights movement that brought about a lot of change. It was a movement to kind of end specifically racial discrimination, but also included other kinds of discrimination. And this massive body of law with Title VII kind of grew out of that. And we talk about these classes of people, we define them as protected classes. And again, for our purposes, we're focused more on the employment discrimination component of this. So broadly speaking, Title VII prohibits discrimination against any of these workers, applicants to work. It covers all the stages of employment. So think about the hiring process when someone's trying to get a job, when they've been employed by somebody, they're already a worker, processes that happen within the scope of employment when it comes to like discipline, getting a promotion, being awarded like benefits, getting your vacation approved, anything like that. Also through the discharge process, if someone's getting let go, what does that do? And so discrimination is banned at all those stages of employment. A lot of times we think about employment while someone is a worker. We got to remember it includes, the full timeline of applying to get that job and the process of discharge from employment. And it prevents or prohibits, doesn't prevent necessarily, people still make their own decisions and behave their own way. But the idea of this law is to prohibit discrimination against workers, employees, applicants, union members on the basis of race, color, national origin, religion, and gender. And it applies to employers that have at least 15 employees, or labor unions with at least 15, employment agencies that provide, workers, government agencies, things. And when it applies to an employer, like they meet the requirements that they have to follow the law in Title VII, it also protects undocumented workers. Does that surprise anybody? When you think about what we've learned early in the semester about standing, and who can bring lawsuits and who's protected under the law, that typically is something that applies to people with citizenship. They're going to be covered by Title VII, that bringing a claim for discrimination, like saying I'm being discriminated against because of my race, my color, my national origin, whatever, that as part of that process, that's something that isn't. It's interesting to think about. Okay, so part of Title VII and the creation and implementation of prohibiting discrimination, we have some more alphabet soup for you, more administrative agencies. The Equal Employment Opportunity Commission, the EEOC. They are the people that are charged with monitoring compliance for Title VII. If an employee is alleging that they've been discriminated against, their first step is they file a claim with the EEOC. And that's before they're allowed to even bring a lawsuit or anything like that. They have to file with the EEOC against their employer. And the EEOC doesn't necessarily investigate every single claim that's sent to them, but they will investigate what they might consider a priority case. Or if there's a particular area of trying to kind of like further define or develop the law, they might investigate cases that are similar nature or something. And then the EEOC can decide through their investigation if they are going to, like send the parties to like a mediation, try to get a settlement agreement. Mediation is voluntary, right? So no one can force you into a deal of mediation. You can agree to go there voluntarily and then see if you can work something out. And sometimes you can, sometimes you can't. And if the voluntary process of trying to reach a settlement agreement fails, then the EEOC can decide to file a suit against the employer after that process on the employee's behalf. So they're the ones suing because of the situation that happened with this employee or this worker, Or they can issue a letter that's known as a right to sue letter. And an employee, before an employee can move forward in like traditional litigation process, they have to have that right to sue letter saying that the EEOC is deciding not to pursue this themselves and they can sue. So the right to sue letter doesn't necessarily mean someone does or doesn't have a claim. It just means the EEOC is not pursuing that claim. Does that make sense? And so the thing about multiple claims of the same type, so if someone wants to bring like a class action suit, they have to show that there is a company-wide policy discrimination. So that had a common effect on all the plaintiffs that are covered by the action. So they can't just say, oh, well, because we have this thing in common that makes us a class, we're going to sue together. They have to show that it's a broad problem, not a narrow problem. And what's important to realize when we talk about discrimination is that discrimination happens kind of in two different ways. So when you guys think about someone being discriminated against at work, what kind of things do you think about? What does discrimination look like?
You called me.
Okay,
Maybe
someone being called names like a slur or a derogatory. Okay,
maybe like pay, someone's getting paid
okay,
more or less because of their race or gender or whatever.
okay,
Make them do like the crappy jobs. They do like.
okay.
grunt work type stuff.
Someone getting bad assignments, missing out on pay raises or promotions, or being harassed with like, okay. Most of the examples when I typically ask students to like think about what discrimination looks like in a workplace, they think about intentional behaviors. Okay, so someone is intentionally discriminating, you know, to someone like because of that intentional behavior. And when we have intentional discrimination, we call that disparate treatment discrimination. Okay, so the way someone is treated is discriminatory. Okay, an employer is intentionally discriminating against an employee, whatever kind of discrimination, you know, based, like you said, sometimes based on their gender, based on their ethnicity, their race, their color, something like that. But it's that kind of behaviors is what we kind of think of. And intent is sometimes difficult to prove, you know. Courts have established kind of a procedure for resolving these disparate treatment cases that, like, you know, kind of breaking it down into a process, just like we've learned with other situations in civil cases or criminal cases. We've talked about like the elements of a crime. You know, if you're going to prove that someone did this crime or prove they don't have a contract, they breached the contract, you go through that process of steps. Well, we've got those steps when we're talking about disparate treatment, that intentional discrimination. And so in order to bring a claim for disparate treatment, for that intentional discrimination, the plaintiff, so the injured party that's bringing that claim, has to make out what we call a prima facie case. So prima facie, you know, is one of those legalese kind of things that we talk about. And setting up that prima facie case is they produce evidence to kind of lay out the foundation of their claim. And think of like maybe a tennis match or something. Like once they have set up all the elements to establish their prima facie case, the ball goes into the defendant's court and they have to like have a rebuttal. Like they have to say, no, that's not the reason that this happened. Like, let's say someone's saying they didn't get hired or they got fired or whatever. It was for a different reason. So they have their opportunity to defend their actions and saying it wasn't because of their status in a protected class. So the elements to establish a prima facie case for the plaintiff, they have to show the following 4 things. So first, they have to provide evidence to demonstrate they were part of a protected class. Okay. The second one is they provide evidence that they applied and were qualified. So this is an example of like the hiring process, because you can see how we would tweak this a little bit for different places. So they're proving their status, you know, that it was based on this immutable characteristic they have. They applied and were qualified for the job in question. So they show evidence of their, you know, resume or whatever to show that they were qualified. They were rejected by the employer. They didn't get that job offer. They didn't get the opportunity to get that job. And the fourth thing is the employer continued to seek applicants. So the plaintiff is saying, I was here, I was qualified, they could have hired me, but because of my whatever, you know, because of the gender I am, because of my race, because of whatever characteristic that they feel like they were discriminated against, I didn't get hired and they kept looking for somebody else. And, or they either kept looking or they hired somebody else, and I could have done this job, but instead of hiring me, they hired me. Whatever what their claim for discrimination is. Once that prima facie case has been established, then the burden shifts, like I said, kind of like a tennis match, falls in the other guy's court for the defendant to say, I had a legal reason for not hiring this plaintiff and had nothing to do with their religion, their race, their sex, or any of that stuff. It was because they weren't who I was looking for. They weren't qualified. They didn't have enough availability, whatever, some other non-protected reason why they didn't get hired. If the employer can give a legit reason why they didn't hire the plaintiff, then again, tennis court, we shift that the ball goes back to the plaintiff's court, the burden goes back to the plaintiff. And in order to prevail in this case, because the defendant provided evidence for what legal basis they had rather than illegal basis for not hiring the plaintiff, and the plaintiff has to then show that the employer's reason is a pretext. So they're saying that's not really the reason. They're just saying that because we're right here in the middle of a lawsuit, and that's a lie. That's not the truth. That's just a pretext. And that the employer's decision was actually motivated by discriminatory intent. So they have to kind of try to show that.
Something that's like, I feel like you could like get out of that very easily as an employer. Like, oh, they didn't interview well, or I didn't like their answers. Is that something that's like they rule in like the plaintiff's favor?
Just like anything else, whoever the person that's hearing the case has to kind of weigh that evidence. Sometimes you have cases like for example, if this was like a hiring case and the plaintiff says, this is my resume, this is my education, this is my background, I was fully qualified for this job. And they're like, no, we didn't hire them because we found out that they never actually graduated. They almost graduated. They're claiming this bachelor's degree in marketing, but we saw they were like 3 credits shy of graduating because they flunked a class their last semester. Well, then the plaintiff can come back and say, no, they really just didn't hire me because of my, whatever, religion, national origin, something. Because the evidence shows they didn't actually request my transcript until we were coming to court as part of discovery. So how would they have known whether I had that degree or not, except for that they just barely requested my transcripts, but based on, the interview and what they had, the information at the time, they didn't hire me because they didn't like the fact that I belonged to this group, whatever, that kind of thing. You see what I'm saying? So like, that's kind of an example where they might have evidence to show that was just a pretext. But again, it is complicated because there's plenty of reasons that you could hire somebody or not hire somebody with how that interview worked or what their availability was or whatever. But then there's a lot of reasons you can't discriminate against. So like, let's say that the woman walks into the interview and she looks like she's pregnant, and the employer is like, by the time we get this person trained, they'll be out on maternity leave, and I don't want to mess with that. I'm going to keep looking for somebody else, and they go and they hire a man instead who doesn't have that situation going on. And the lady's like, I would have been a great employee. I'm more qualified than the guy they hired. They completely rejected me. They were really excited about me over the phone, and when we talked, and then when they saw me in person, there was no hiding the fact that I was carrying a baby, and then they completely rejected me. You know what I mean? Like that would be something that would be harder to overcome in that situation if they hired somebody that was less qualified, whatever. But again, you're right. I mean, these are complicated cases, and sometimes it is hard to, just like I put in this, like it's sometimes hard to prove or disprove someone's intent. And just like everything else we've learned about, litigation is an expensive and long process. And it's also why these cases sometimes are better off settled. Someone can have justice faster and can move forward. But again, if the employer didn't have a legal reason for taking the adverse employment action, so either the defendant has a chance to, for their rebuttal and it doesn't hold water, or it feels like a pretext, their evidence is not really very compelling, whatever reason, then the plaintiff's going to win. If they can articulate a legitimate reason for the action, burden shifts back to the plaintiff, and the plaintiff has to show some kind of evidence or somehow be compelling enough with their evidence to convince, the fact finder that this is just a pretext and this isn't real. Okay, so that's the kind of intentional discrimination that most people are more familiar with or think of when they think about discrimination. The kind that might be less familiar to you or newer as you learn about in this chapter is unintentional discrimination. So we call that disparate impact discrimination. So something that has an impact of discrimination, even if it doesn't look on the face or on the surface like it has anything to do with discrimination. So this is the discrimination that results from certain employer actions that, again, on their surface don't look like they're intending to discriminate against anyone, but they have a discriminatory effect. So sometimes when an employer has certain tests for a job, they can result in like disqualifying a portion of people, and it may not even actually be something that's that important for a job. So think about a physical strength test for a job. There could be a company that they just give everybody this physical strength test, even if they're going to be working in the office or whatever. Like it's a construction company, and they're like, well, sometimes people might sub for other people. So we're going to make sure that before anybody gets hired, they can pick up this 50-pound bag of cement, run it back and forth, and do all these things or whatever. A test like that, if you have someone who doesn't have a lot of physical strength, because maybe it's a woman who's small and not physically fit enough to pass this test that they have for everybody at the construction company, but the job she's applying for is to work in the front office and file papers and call people and collect on bills and things like that. Is that really a necessary part of her job? Is it fair to put that applicant through this particular test and make everybody who's applying to this company do this physical test when it only affects these kinds of jobs, those kind of things? And so the examples you'll find when it comes to disparate impact cases are going to be things like that, where someone was weeding out certain applicants, but not for a justified reason. And it resulted in a discriminatory impact where this company has very few women or no women at all working for them because of this extreme physical test that they were requiring all employees to pass, regardless of what kind of role they were playing in the company. So courts have established rules and procedures to try to resolve these disparate impact type cases. If someone's complaining that they have been discriminated against because of some test or some policy or something that resulted in discrimination, they have to first show how the employer's practices or the procedures or whatever their action is have an effect of discrimination. And that's their prima facie case. So once they've made out the prima facie case, again, just like with the intentional discrimination cases, we have that tennis ball and it shifts over to the defendant's court to provide a legal justification that shows why that practice, why that action, whatever they did, was justified. And so there's two ways that we can kind of show that unintentional disparate impact discrimination. The first one, we'll call this like the pool of applicants or the pool of qualified individuals available in the local market. So the plaintiff can show that as a result of whatever requirement, whatever that activity that they're doing is, the percentage of the employee's workforce doesn't reflect the percentage of that group in the pool of qualified applicants. So again, like the qualified applicants that would be available for this job in this community might be 50% men, 50% women. Because of this extreme physical fitness test or whatever the test is, the result is that the workforce percentage results in 90% men and 10% women, whereas qualified applicants are like 50-50. Okay, and then by comparing that selection rate of members and non-members of a protected class, the selection rate for protected class that's less than 4/5 or 80%, that rate can be evidence as having an impact of discrimination. Okay, so it's a little bit of math. It's not exact. Like no one can really expect a workforce to reflect exactly what the potential applicants are, right? Not everybody that's available to apply for a job applies for a job. People apply for jobs when they're looking for jobs. People apply for jobs when they hear about it through their friends and their neighbors or online or whatever. And so the idea is that we're using a ratio of 4/5 or 80% to say, is it close to reflecting, these potential applicants? Not exact, because it would kind of be ridiculous if we expected everybody to be exact on these percentages. But if it's way off, then we'll say, okay, something fishy is going on, like this doesn't make sense because it shouldn't be that far off. Okay. Title VII prohibits discrimination. We talked about that on the basis of race, color, or national origin. So let's talk about discrimination based on these categories kind of together. When we're talking about race, under the law, the way it's been interpreted in cases, race applies to someone's ancestry, or ethnic characteristics they may have based on being part of a group of people. National origin refers to being discriminated against based on their birth in another country or their family's birth coming from another country, their ancestry, their culture. So sometimes it can be a little tricky if someone is, one of the examples earlier, we talked about someone having being harassed with derogatory language or slurs or something like that. Sometimes it can be a little fuzzy. Is that person being harassed based on their race? Is that person being harassed based on their national origin? Essentially, that's why we're kind of looking at these together in the same category. If something the employer is doing with their standards or their policies for promoting people, for selecting people for work, has this discriminatory effect on these protected classes, then it looks like there's some kind of illegal, prohibited discrimination that's happening. So in order to avoid liability as an employer, they need to show that their standards or policies have a significant relationship. So some substantial, demonstrative relationship to legit, realistic qualifications for that job in question. What do you think might be a legit connection between qualifications for a job in question that would select people from different backgrounds when we're talking about their race, their color, their national origin? Is there something that could legitimately be part of the job in question?
Something that of that culture that would affect.
Why you'd specifically be going after someone a realistic job qualification. I don't want to say too much because I can think of some in my head, but this is you're brand new in this chapter. You haven't been exposed to some of the cases in the textbook yet or anything. So what could be a legit qualification for a job that would select employees in one category over another when we're talking about race, color, national origin?
Good English, able to speak well.
Okay. That could be a legit qualification for a job. If the job requires you to speak English and you don't speak English, it might have discriminatory effect, but it's a legitimate, realistic qualification for a job. What about the reverse? If it's a school that is promising a bilingual education and they're specifically looking for someone that is a native speaker of a particular language. There are going to be people that are not qualified or get rejected for that job because they're not native speakers of Chinese. And this is a school that is promising bilingual education in English and Chinese here in Atlanta or something, that kind of stuff. So yeah, if they want to avoid liability, they've got to show that whatever standard, policy, qualification they have has a, substantial, demonstrable relationship to the qualifications of the job in order to avoid this being illegal discrimination. And this also protects people who were overlooked for a job with reverse discrimination. I don't really like the term reverse discrimination because I think if you're being discriminated against because of something that's an immutable characteristic, it's still discrimination. But to differentiate between the minority protected classes defined in Title VII, we'll call it reverse discrimination. But anyone who's discriminated against for something that is an immutable characteristic is wrong. Title VII says we cannot discriminate against people based on race, color, national origin. And so that protects people from being in situations where someone is, because an employer is going to be safe and protected if they are doing things the right way. They are hiring the most qualified candidates for jobs. They're casting a wide net for applicants. They're not just hiring the people that they go to church with and the people who live in their neighborhood. That's a really fast way to fall into that unintentional discrimination, where the result of the workforce doesn't reflect the pool of qualified applicants. But if someone is doing something different and they're trying to put together a diversified workforce by overlooking qualified candidates and trying to make the picture on the brochure look a certain way, that's wrong too. That's not diversity. That's not finding the right candidates and hiring the best people. You're still making an illegal decision based on someone's race or national origin or something, or color of their skin.
That'd be kind of crazy though.
Like language requirements, I've seen cases where that was legit. I've seen gender requirements for someone who's working like in a locker room at a gym, like those kind of situations where the sex of the employee matches the sex of the people that are in the changing facility or working in certain industries. But in general, I've never seen it for color.
The DEA, they do like their stinging stuff. And they don't want like Hispanic people to get hold of the able to be like I guess I do. Not that they get hired.
Well, but even then, I would still bet that color still wouldn't be a legit qualification because and again, reverse discrimination against members of the majority group that aren't necessarily that minority protected class. That kind of discrimination is not okay. And people who are victims of racial or ethnic discrimination, in addition to being protected by Title VII, this is what I talked about with the older laws that predate Title VII, which is only 60 years old, going all the way back to 1866, post-Civil War era. 42 United States Code section 1981, we refer to those as 1981 claims. It prohibits discrimination on the base of race or ethnicity in the formation or enforcement of contracts. And so you can see how contract law can have an effect on employment law issues. And so there are going to be circumstances where someone might have a potential section 1981 claim. And you're saying, well, why would that matter? And it matters in the procedures of things. Like, how we've talked before about, we have substantive law, which is that meat and potatoes, the rights and responsibilities of law, and procedural law, timelines, how long you have to respond, how long you have to bring a claim. Some of the procedural aspects of these 1981 claims are different. And so sometimes someone can bring that kind of claim, maybe if they're barred from a Title VII claim because of procedural aspect.
When you're in the job, you're kind of making a contract with your employer, like you're making a contract together, right?
Mm-hmm. And there might be a claim for, we talked about employment contracts that are written down and signed, everybody's aware of the contract. And then there's employment contracts that might be implied for other reasons. And so if someone can establish a contract relationship, they can maybe establish a claim in 1981. So Title VII prohibits government employers, private employers, union employers, people with more than 15 employees against discrimination also based on religion. So we talked about color, ethnicity, national origin categories. Another group of protected class is, prohibiting discrimination based on religion. They can't be treated more or less favorably based on their religious beliefs or practices. And an employer cannot require employees to participate in any religious activity or forbid them from participating in one. Okay, so this is striking a delicate balance. If the employees at a company, you guys are future business leaders, you're the owner of the business, you're the leader in the business. An employee comes to you and they want to start having prayer sessions or religious study or scripture study or something like that. Lunch hour. And so it's important to strike that balance of not treating anyone more or less favorably based on their religious beliefs or practices, and trying to respect and accommodate those where they can be reasonably accommodated. So an employer by law must reasonably accommodate the religious practices and sincerely held religious beliefs of its employees, unless doing so causes undue hardship. Okay, if someone comes to you and they say, again, they want to get together at lunchtime and have prayer sessions or scripture study or something like that, how easy is that to accommodate? Sure, you can have the conference room. It can be scheduled on the regular, as you know, whatever, something that's really easy to accommodate. Now it gets complicated because who's to say what is sincere, what's not sincere? Something that might seem illogical or unusual or irrational to someone else might be very sincerely held, belief of someone else. But the real standard for this is going to be what's reasonable to accommodate. So whether or not you understand someone else's religious conviction isn't really the issue. It's about what are they asking for and can you accommodate it? If they're saying, because of my religious convictions, I cannot work on Sundays because that is my religious Sabbath. How are you going to handle that? Can you manage to give them all their Sundays off? Or do you have a company policy where people really like their weekends, but you're open 7 days a week, so maybe try to rotate through who gets their Sundays off or what, it's going to come down to that. Can your business function if you give them their Sundays off? Is it going to hurt everyone else is there a lot of people that want Sundays off to where you can't function if everybody's gone on Sundays? Can you give them half their Sundays off?
Treat the other people like unfairly.
Right. Because remember, the deal is someone's not being treated more or less favorably because of the accommodation. So someone's not like in with the boss and getting promotions and raises and more favorable treatment because they go with the boss to this lunchtime religious activity, right? Like that wouldn't be okay. There's nothing wrong with those things happening, but it's got to be very clear that participation or non-participation in before work, lunch hour, whatever, isn't going to affect someone's work life. And in this area, we're in a part of the country known as the Bible Belt. So we have predominant religious practices in our area, and then we have less common or minority religious. That's something that as you guys go into future leadership roles in business, you got to keep that stuff in mind and make sure that you're balancing and respecting all of your employees. And remembering that the law says an employer must reasonably accommodate.
We had with the military, with like the COVID-19 stuff, they would have a lot of people thrown out the religious exemption from it. So literally our chaplain, like the RP, would pull each person that did one, like sitting them down, like talking to them about all of it to see if they actually like believed it or they were just trying to get out of it. And not a lot of people made it through.
Right. Because before that, there were established religions that people just sort of, if you knew something about this religion or that religion, you knew that this particular religion had certain medical standards, like they don't take medicines or they don't accept blood products or they don't whatever, And so if you knew someone that was a part of that particular religious sect, then you wouldn't be surprised if that was something they didn't do, because they also have it on their the background card that they don't receive blood products or they don't receive whatever, and yet, yeah, like that's complicated for the employer, right? Is all of a sudden people are submitting religious exemptions for something and you're like, how do I handle this the right way? How do I reasonably accommodate a sincerely held religious belief, at the same time prevent people from trying to scam a system because of a insincere pretend religious belief? Like it's hard. Those of you, as you go take on the world and follow your dreams, like it's important to think about the hard things and think about the hard questions before they arise. And how would you handle that? Whose advice would you seek? How would you figure that out? Because people were having to figure that out at businesses and companies all over the last few years. Okay, so that's religion. Next category is gender. So discrimination based on gender is also prohibited. When we talk about in the language of Title VII, they call it discrimination on the basis of sex. The basis of sex is expanded to sex, gender, and it also covers gender-related conditions. So, for example, pregnancy is covered under Title VII because pregnancy is a condition that is connected to the female gender. And, you know, in the past, before Title VII, it was not uncommon to see ads in the newspaper advertising for a man, looking for a man to do this job, looking for a woman to do this job. That ended with sex being included in Title VII. So jobs can't be advertised as this is a job for a man, this is a job for a woman, unless they can prove that gender of the applicant is essential to the job. We kind of touched on that when I was talking about like, maybe they're an attendant for like a locker room at a gym. People are naked and changing and it's just not appropriate. People would feel uncomfortable to have someone that's not their same gender in that kind of situation. They're prohibited from having separate male and female seniority lists. Again, like sometimes people say, okay, well, there's a problem in this company. You know, when you get to the top levels of management, it doesn't reflect the same kind of ratios that exist in the employees at a whole. Like what's happening as people get promoted? Why aren't women getting promoted? Why aren't people of this particular racial background or ethnicity getting promoted? Like what's going on in the process? You know, that's not promoting people at the top that look like the people that are working at the bottom. And they can't like fix that. If somebody says, oh, you don't have any women in leadership, they can't have like a separate list for women to promote women. Like that's not fair to people who are not women if they're getting promoted faster or something. The reality is that good practices, good procedures will result in the best people getting promoted, and it will eventually reflect the appropriate ratios because everybody's being offered those opportunities and training, those kind of things. And to succeed in a lawsuit for sex discrimination, a plaintiff has to demonstrate that gender was a determining factor in that employer's decision to hire, fire, not promote them, something like that. I kind of already touched on this. Pregnancy is included in Title VII as part of sex discrimination because pregnancy is a condition connected to someone's sex. And an employer can't discriminate against a pregnant woman by withholding benefits available to others. They can't prevent someone from being eligible for promotion because they took time off for maternity leave, you know, that kind of thing. Like those things are protected. And recently, pregnancy discrimination has been expanded to post-pregnancy conditions, like women are allowed an appropriate time to recover from giving birth to a child or even adopting a child to have that same kind of maternity leave. A lot of companies have expanded that to be maternity or paternity leave to give fathers the same opportunity for, you know, that bonding and recovery from having a new baby in the house or an adopted child, even if it's not a newborn. And then post-pregnancy discrimination also covers and protects nursing mothers. It's relatively new law that's been passed through, so it's not even in your textbook yet, so it won't be on your test, but pregnancy protections have expanded to include protections for moms who are nursing babies to have the opportunity to like pump at work and get extra breaks and those kind of things in order to promote that, you know, as a post-pregnancy condition related to their gender. We talked a little bit about when you guys were bringing up examples of what you think of when you think of discrimination. We talked about wage discrimination or pay issues. The Equal Pay Act requires equal pay for female and male workers that work at the same establishment. They do the same job. There's not really a reason for someone who's doing the same job, has the same kind of experience, the same kind of workload, to have different pay just based on gender. And so in order to determine whether the Equal Pay Act has been violated, they are going to look at the duties of the jobs, the seniority, the experience, and see if there's any other reason for that wage differential. Because those things are legitimate, have nothing to do with discrimination, right? If someone's making more money because they have more experience or more seniority or something, that makes sense. If they're making more money and there's no other factor at play other than gender, that is a problem. And that is going to look like it's violating the Equal Pay Act. And we are basically running out of time, but I will end this conversation with, there was a little blurb and that I had in my notes for today, talking about how as we increase our global economy, how good this is for eliminating these kind of barriers. Because essentially that's why we have laws protecting against discrimination, is to eliminate barriers for people. For something they can't control, you know, you didn't control who you were born as, how you were born, anything. It's not fair to hold those things against anybody, period, or to favor someone because of those characteristics. That's just not okay. And as we open trade globally, we have less constraints when we do international business. We have more information and communicating technology available, and it creates more jobs and more opportunities for women worldwide. Because there's still a lot of countries that are behind where we were before we had this 60 years ago. You know, gender inequality is a huge impediment to growth economically around the world in a lot of countries. But as we increase trade, we increase global economy, people have more access to the internet, smartphones, they can see more, they know more, they see what other cultures look like, they see how business works. And as they increase in their knowledge about other cultures and other places around the world, it helps improve the way that these other cultures relate to women in the economy. And in turn can really help change local attitudes and behaviors in a more rapid pace than we've ever seen possible before. So just like the conversation about women in professional sports has kind of changed, it could possibly change the circumstances for these young rookies and the future of those kind of things. In business, as you guys go into your future business careers, you know, you will probably have a front seat to seeing a lot of things change worldwide, where more opportunities for women in careers that are actually like valuable to them can support their family kind of careers. See in other countries kind of broaden their horizon, provide more opportunities. So we are out of time for today.